Yeah, welcome everyone. First, let me just, for the purposes of emphasis, participants should understand that we need to mute our microphones when we are not actually speaking. And we are actually encouraged also to write all our questions in the chat. If possible, that will be helpful. You can do that for us. And participants should also raise their hands, indicate by raising their hands if they want to take the floor. These are just etiquettes that all of us know, but for purposes of emphasis, we should know. And again, uh, the Speaker of the House of Representatives here in Nigeria has delegated Honorable Osai, Nicola Osai, who is a very senior member of the PGA. He is a third-time member of the Nigeria's National Assembly. He is currently the chairman, House Committee on Treaty, Protocols, and Agreement. And he is the gentleman that already has a bill in the House on war crimes against humanity, war crimes and genocide for related matters, HB 945. It was read the first time on the 4th of July, 2000. It is awaiting the second reading. So this is a very important person here, our member. And again, let me just read my own remark, welcome remark. It gives me a great pleasure to welcome participants representing several African states and other states to the workshop on fight against impunity for mass atrocities under the Rome Statute of the International Criminal Court, ICC, and the promotion of the rule of law. This workshop is part of PGA's International Law and Human Rights Program, organized for regional parliaments to share knowledge and experience on regional developments relating to crimes within the scope of the Rome Statute of the International Criminal Court. It is significant to emphasize that this workshop is primarily organized by PGA to provide a platform for regional discussions between legislators on accountability for international crimes, challenges, prospects, and diversified actions initiated by countries against international crimes. Distinguished participants, it is worth remembering that the 20th century witnessed some of the worst atrocities in the history of humanities, accounting for more than 86 million civilians dead in over 250 conflicts in the past 50 years alone. This sad development compelled the international community through the United Nations to resolve to take action to bring the perpetrators of most heinous crimes against humanity to justice. It was this same development that influenced the creation of permanent International Criminal Court on July 17 of 1998. With the adoption of the Rome Statute, which came into force on July 1st, 2002, upon 60 ratifications. As of June 30, 2009, 108 countries have ratified or acceded to the ICC statute. Well, the statute was signed on 1st of June 2000 and ratified on 27 September 2001 by Nigeria, along with many other countries. As legislators charged with the responsibility of making law for the peace, order, and good governance, there is no time better than now to support the realization of objectives of International Criminal Court, ICC, which include safeguarding higher values such as the protection of human rights and obligations that transcend state borders, and ensuring accountability for those responsible for the commission of such crimes, so as to put an end to impunity that is often associated with violations. At this juncture, it is my sincere honor to welcome our distinguished participants for this important workshop. It is my hope that the workshop will achieve the desired goal of addressing the challenges of international crime against humanity through effective lawmaking. I thank you all for participation, and I wish the event a huge success. Thank you so much.
Thank you very much, Honorable Namdas. I am David Donatkaten, the Secretary General of PGA, and I call upon Honorable Osai, Nicholas Osai, on behalf of the Speaker of the Parliament of the Federal Republic of Nigeria. Honorable. Please unmute. Honorable Ossai, if you could unmute your microphone. Okay, perfect.
Okay. Are you hearing me now?
Yes.
Yeah, thank you. First of all, I want to thank the chairman of Nigerian PGA, Right Honorable Namdas, and all the participants. Opening remark by the Right Honorable Speaker of the House of Representatives, National Assembly, Right Honorable Femi Gbajame-Abila, presented at the virtual workshops on the fight against impunity for mass atrocity under the Rome Statute of the International Criminal Court, ICC, organized by the Parliamentarians for Global Actions. It is with honor and gratitude I welcome you all to this symbolic workshop on the fight against impunity for mass atrocity under the Rome Statute of the International Criminal Court, put together by the Parliamentarians for Global Action, PGA, and co-hosted by Nigerian national groups of PGA and ECOWAS Parliament. I commend PGA for their commitment in informing and mobilizing parliamentarians from all regions of the world to defend human rights and the rule of law, and also creating the right environment to build the needed political will by government towards fighting impunity for the most serious crimes under international law. The workshop shouldn't have come at a better time than now, when there is an absolute need for parliamentarians in West African region, in particular, and African at large, to fight against impunity for mass atrocity, which include genocide, crime against humanity, war crime, and crime of aggression, its preventions and development of effective accountability mechanism at the national level and promotion of international cooperation. Distinguished ladies and gentlemen, in anticipating a clear roadmap for the fight against impunity, the Nigerian National Assembly is considering some relevant bills, which by special grace of God, I and some others have initiated, which is geared towards improving the Rome status and its accountability mechanism in Nigeria. Interestingly, we are also reenacting some of our laws to make sure that executive integrate the parliamentarians, especially the Law and Treaty Making Procedure Act, which I also and my committee have initiated to bring that kind of synergy between the executive and legislature to address many concerns that has not been addressed over the years. It is also significant to note that the final report and recommendation from this workshop will contribute immensely to the bills before the National Assembly. Therefore, the Nigerian Parliament looks forward to receiving your recommendation at the end of the workshop through the Nigerian national groups of PGA. Interestingly, on issues of ratification and domestication of the Rome Statute within the state party, in line with the provision of amendment of the statutes through a proposal by state party as stated in articles and Article 121 and 123, it is important that the PGA, working with other relevant global organizations, initiates process to ensure state party parliament domesticate international instruments to give effect and also to popularize the operation of the statute within the state party. The executive arm of government shouldn't propose an amendment to the statutes without the input of the parliament globally. this is very, very key and very important on issues of strengthening also the parliament. In the Parliament of Nigerian National Assembly, which I've already said I sponsor, and I also think that the role of parliament and parliamentarians is very critical in winning the fight against impunity for mass atrocity. I also expect the ICC prosecutor to work closely with the National Assembly of Nigeria and the Nigerian national groups of PGA, drawing inspiration from oversight outcomes of the parliament in dealing with issues of crime against humanity and other crimes. Thank you, and God bless you for this great program.
Thank you very much, Honorable Osai, and of course our gratefulness goes to the Honorable Olufemi Aken Gabayamila, the Speaker of the House of Representatives, who delivered this incredibly good statement that is really inspiring our actions today. And as the Honorable Speaker remarks noted, we are organizing this meeting inviting not only honorable members of the Parliament of Nigeria, where we have an indefatigable leader like Honorable Namdas on behalf of PGA, but also the members from the ECOWAS country that have an interest and relevance to this topic. The ECOWAS being the regional group of 15 member states, out of which 13 are already state parties to the Rome Statute. Therefore, we can move to the first presentation on the context, impunity for serious violations of human rights and international crimes in West Africa. And we are inviting our colleague, Ms. Oreya Balagaye, who is trial lawyer at the Office of the Prosecutor of the International Criminal Court. Ms. Balagaye, I think you are joining us from The Hague, if I'm not mistaken. Please take the floor.
Good afternoon to you all. Thank you very much for this invitation. Whenever I'm in the midst of West Africans, I'm tempted to brag about the fact that jollof rice originated from the Gambia and Senegal. But whenever I see Nigerians, it's always a different story because we're outnumbered, and therefore I'll resist that temptation to brag any further. Thank you for this invitation. Honorable members, distinguished ladies and gentlemen, good afternoon to you all. It is a deep honor for me to address you on this very important workshop addressing the topic of impunity for mass atrocity crimes under the Rome Statute and promoting the rule of law. This honor is in large part due to your role, your critical role as parliamentarians, which gives you the authority as well as the ability to take meaningful action in the fight against impunity. I would like to express my gratitude to both PGA in general, as well as PGA, the Nigeria group, for this opportunity. My presentation on the context will hopefully lay the foundation for subsequent discussions about this topic. My perspective is informed not just by my experience as an international criminal lawyer, having worked for about 14 years at the ICC in the prosecution division, but also as my recent stint in the Gambia, serving as Deputy Lead Counsel of the Truth, Reconciliation and Reparations Commission. I believe that experience from both an international as well as a national domestic setting may provide you with some opportunities, insights, as well as an idea of some of the challenges we face, but also what we try to do in order to address those challenges. From an international perspective, I will begin by giving you a brief overview of the ICC's preliminary examinations as well as investigations in West Africa. Thereafter, I will highlight a few issues within the Gambian context, just to illustrate some of those challenges that I will identify prior to that. So a brief overview of the ICC's examination and investigations in West Africa. I'm also keeping an eye on the clock to make sure I don't overrun my time. A key part of the Office of the Prosecutor's mandate, as many of you know, is to determine whether a situation meets the legal criteria established by the Rome Statute to warrant investigation by the office. The OTP discharges this obligation by conducting preliminary examinations. And in that regard, we analyze all the communications received, as well as information that is readily available in order to determine a number of legal requirements. As you may know, jurisdiction is one of those. So we look at the temporal jurisdiction. We look at whether we have jurisdiction from either a territorial or a personal perspective. We look at material jurisdiction. So in terms of the subject matter of the crimes allegedly committed, we consider admissibility. And in that, we look at complementarity as well as gravity. As you will know, the ICC is complementary to national systems. So we do not have that primary jurisdiction. It is states parties that have the obligation to investigate and prosecute. And only failing that do we then step in if a state is unwilling or unable to do so. Another factor is the interest of justice to determine whether or not we would proceed to an investigation. In general, there are various ways of triggering the OTP's initiation of a preliminary examination. And this can be based on information sent by individuals, for example, groups, states, it could be international organizations, it could be non-governmental organizations. It could be based on a referral from either a state party or the UN Security Council, or it could also be based on a declaration lodged by a state that is not a state party, but is accepting the jurisdiction of the court. We call these Article 12.3 declarations. Currently, the OTP has multiple preliminary examinations, as well as 14 investigations in different parts of the world. For our purposes, I will focus on West Africa. The court's preliminary examinations are focused on 4 main situations. For those of you, you may know that we've been looking at Guinea, which is in the preliminary examination phase. We're also looking at Nigeria, which is in an interim phase because the preliminary examination has concluded, but we're yet to open an investigation. The third situation is the situation of Cote d'Ivoire, which is in investigation phase, and then the situation in Mali, which is in investigation phase as well. So a little background on Guinea. In terms of Guinea, we've been looking at the events in Guinea since 14th of October, 2009. So that preliminary examination is based on the fact that Guinea is a state party to the ICC. It ratified the Rome Statute on 14th July 2003, and therefore the court has jurisdiction in Guinea from 1st of October 2003. The incident that is under our consideration in Guinea dates back to the events of 2009. So some of you would probably know that in December 2008, the death of former President Lansana Conté led to a military takeover. This was by Captain Moussa Dadis Camara and other members of the military forces. They staged a military coup and established a military regime. Now, despite the promise to hand over power to a civilian president, subsequently, there were statements that indicated that Captain Camara might run for president, which led to protests by opposition parties as well as civil society. And so this culminated on the 28th of September 2009, which is Guinea's Independence Day. It culminated in an incident that took place at the National Stadium. An opposition gathering at the National Stadium was violently suppressed by members of the security forces in what became known as the 28th September Massacre. So based on the OTP's analysis, we found that there was reasonable basis to believe that crimes against humanity were committed based on that incident. So we looked at the incidents of the 28th September 2009, as well as what happened in the immediate aftermath. And some of the crimes that the court found were allegations of murder, imprisonment, or severe deprivation of personal liberty, torture, rape, and other forms of sexual violence, persecution, as well as enforced disappearances of persons. Now, following a lengthy national proceedings in Guinea, so where they conducted their own investigations, as well as issued multiple indictments, which was then followed by appeals in the courts, it was announced that a trial would take place in 2020. However, there are a number of challenges identified by the Guinean authorities, including identifying a suitable courtroom and a number of other issues that need to be dealt with in order for a trial to commence. So one particular approach that the office has taken in this particular situation is that of positive complementarity. And so the office continues to encourage different stakeholders to support national efforts. And to some extent, the court has also engaged with the authorities there and made a number of suggestions to be considered. So there are suggestions around training of personnel, designating what I mentioned earlier, which is the suitable courtroom for trial. Comprehensive security scheme for the protection of witnesses was one, as well as justice officials, as well as establishing a broad communication plan. So the office is engaged in those efforts because in line with our objective, which is we're only complementary and come in when national proceedings or national investigations and prosecutions don't take place. In relation to Nigeria, I note the time, so I'll move on much quicker. In relation to Nigeria, which is probably the one that you're all most familiar with, the office announced that it's conducting a preliminary examination on the 18th of November, 2010. Nigeria is a state party. As you know, it ratified the Rome Statute on the 27th September 2001, as has been mentioned. The office identified a total of about 10 potential cases of war crimes and crimes against humanity. And of course, these are preliminary assessments because the office can only understand the scope of these crimes once it conducts an actual investigation. So the office found that a reasonable basis to believe that Boko Haram, as well as its splinter groups, as well as the Nigerian security forces, allegedly committed war crimes and crimes against humanity. So the office is looking at events since July 2009, as well as June 2011. Some of the crimes are murder, rape, sexual slavery, enslavement, torture, other inhumane acts such as forced marriages, as well as persecution on gender and religious grounds. So just to say that the court remains engaged in the Nigerian situation, despite the fact that we're in this interim phase where the preliminary examination has closed, but the investigations have not yet been opened. Regarding Côte d'Ivoire, Côte d'Ivoire at the time when the court started looking at Côte d'Ivoire was not a state party. So it lodged a declaration accepting the court's jurisdiction, even though subsequently it became a state party many years later. So on 15th of February, 2013. So the OTP opened an investigation in Côte d'Ivoire on the 3rd of October, 2011, looking into the post-election violence that happened between 2010 and 2011. As many of you will recall, there was a dispute as to the winner of the presidential election, some proclaiming that it was Mr. Laurent Gbagbo who won, while others proclaimed that it was Mr. Alassane Ouattara. And so this dispute led to a situation where there was post-election violence. As many of you will know, then we ended up with a CIV1 case against Mr. Charles Blé Goudé and Mr. Laurent Gbagbo, which resulted in an acquittal. These were based on charges of crimes against humanity. I will not say much more about that because I also know that my colleague will give more updates on cases at the court. So Mr. Amadiba will have the task of telling you a bit more about those cases, but we do have a case still against Mrs. Simone Gbagbo, as well as the OTP is still engaged in Côte d'Ivoire as we're looking into both sides of the conflict. So it's not just investigations on one side. In terms of Mali, very quickly, as the office, as many of you know, we've been engaged in Mali for a while now. So in July 2012, the government referred the situation, and January 2013, we opened an investigation. So looking at northern regions such as Gao, Kidal, Timbuktu, as well as events occurring in the south, such as Bamako. Some of the crimes are both war crimes and crimes against humanity. In the Al-Mahdi case, we focused largely on the destruction of cultural heritage, which was a very important milestone for the office. Mr. Al-Mahdi was sentenced to 9 years, and reparations order has been issued. A second case is the Al-Hassan case, which looks at a broader scope of crimes. So looking at crimes such as persecution based on gender and other section gender-based crimes. But I will leave that for Mr. Ba. Let me quickly just try to move on to focus a bit more on the Gambia and what I can draw out quickly. The Gambia is a good example of some of these issues that are faced in many other countries. So you'll see that from a lot of the crimes that I've mentioned or the alleged perpetrators, we're looking at state actors as well as non-state actors. And there are challenges on both sides. With non-state actors, for example, it's being able to even access territory that they're in control of, or being able to ensure that they abide by certain rules. With state actors, sometimes it may be that some of these actors are still within the system, or even if they've left the system, sometimes they have certain capabilities as a result of that. A lot of the crimes we look at, you'll see that sexual and gender-based crimes form a very significant, or should I say very important part of those crimes, and it should not be overlooked. A lot of the other crimes are also ones that require expertise, as well as forensic capacity, for example. So in Gambia, one big challenge we had at the TRRC was regarding witness protection. So we were obligated to protect witnesses, but there was no witness protection framework in the Gambia. So we didn't have comprehensive legislation on witness protection. We didn't have a lot of the capacity or ability to have individuals trained in witness support. So that was its own challenge, but of course we managed, and we received training from, for example, the ICC registry on that. Psychosocial support is another one. When dealing with victims who are traumatized by these events, it's important to do all that we can to minimize the re-traumatization. So in Gambia, one difficulty was finding people with that experience, having psychosocial experts who could then provide that support. And so one thing we did, for example, was to find someone from an NGO in South Africa, and that person came and trained some of our staff who had some experience in counseling, and that person has stayed on, and the training has continued. And lastly, with forensic expertise, when it comes to exhumations of mass graves, some countries may have this expertise, but in Gambia, we didn't. We had one forensic expert. Apart from that, no equipment, none of that expertise, but we're able to get support from international partners, whether it's Justice Rapid Response, or one other thing to consider would be an organization such as the ICPM, who deal with missing persons, in order to provide support. But these things sometimes require additional agreements or legislation in order to accede to that. So let me just conclude by saying there is considerable experience in the region in relation to a lot of these issues. Of course, tap into local expertise, and certainly regional. There are other countries to turn to, but there's also support from international partners once you identify what kind of support you need. At the end of the day, it's all about good cooperation and collaboration, because this is a common objective to fight impunity. And parliamentarians are a critical partner in this fight. And it's very important that we give you all the support you need. So I would be happy to answer any questions or provide additional information later. Thank you for your kind attention.
Thank you very much, Ms. Balagaye, for your extremely practical examples that you have given to us in respect of 4 situations in the West African region handled by the ICC, as well as the situation in the Gambia, where also the second prosecutor, Fatou Bensouda, comes from. And before giving the floor to your colleague Amadi Ba, who also represents the Office of the Prosecutor and comes from West Africa, from Senegal, we are joined with only 10 minutes of delay so far. So it's not too bad. For me as an Italian, 10 minutes of delay is tolerable. From the UK, we have Professor Dino Kritsiodis, who is teaching public international law and is the head of unit of international humanitarian law at Nottingham International Law and Security Center at University of Nottingham, United Kingdom. Professor Kritsiodis, is the first time you join a PGA meeting. One day we hope to meet you in person, but you give us a great honor to be with us, and you will address the topic of accountability for international crimes. Why is it important? Professor?
Mr. Chair, thank you for those introductory comments. Distinguished members of the National Assembly of Nigeria and the ECOWAS Parliament, the Honourable Abdulrazak Namdas and the Parliamentarians for Global Action, distinguished participants, I'm delighted and indeed honoured to be addressing this session and warmly accept the invitation of Parliamentarians for Global Action to contribute to this timely workshop on the fight against impunity for mass atrocities under the Rome Statute. It is significant that also attending this august session are ECOWAS Parliament members who are equally committed to upholding the rule of law in their respective jurisdictions, but also internationally, which explains why the focus of the proceedings today is on one institution in particular, the International Criminal Court. As part of my introduction, I should say that I'm Professor of Public International Law at the University of Nottingham, where I've taught since 1994. But I'm also a regular faculty member of the Oxford Master's Programme in Human Rights, where I share responsibility for the classes taught there each summer in international humanitarian law. And I'm delighted to see some familiar faces from that cohort, from my former Oxford students, Frederica Schwein-Hoffarova and John Baluzet, who are in attendance. It never ceases to amaze me that it remains necessary, urgent even, to train the next generation of lawyers in the traditions and thinking of the Geneva Conventions. And these seem to be an inescapable feature of human life, no matter where one finds oneself on the planet. One of that next generation of lawyers is Mr. Anjola Alabi, currently enrolled as an undergraduate law student at the University of Nottingham, and himself a citizen of Nigeria. And he too is joining us for today's session. I wish to place on record my appreciations for Mr. Alabi's excellent research assistance in helping me prepare the remarks that I will share with you today. I come to the congregation as a public international lawyer, specializing in the field of international humanitarian law, and to a less extent, international criminal law. However, I'm also speaking to you as a citizen of the Republic of Zimbabwe. And I should mention that I don't want to enter the dispute about the nationality of jollof rice. I'm just happy that there is jollof rice. And I'm fully mindful of the concerns that have been expressed many times over, that the International Criminal Court has essentially become the International Criminal Court for Africa, exhibiting a disproportionate interest in one continent in particular, at the possible expense of all the others. A good example of this way of thinking can be found in the parting words of the Republic of Burundi when it withdrew from the statute of the court in October 2017, that the court has shown itself to be a political instrument and weapon used by the West to enslave other states, and that exiting the statute was a defense of sovereignty and national pride. One has the feeling that those words are very much the tone of Brexit, dare I say. There is no doubt about the strength of feelings that have developed about and indeed against the court. Political emotions have been running at an all-time high. But to be sure, the departure of Burundi has not been followed by the wave of exits that have been predicted from African states. The Gambia, for example, has not made good on its threat to leave the court, and the Republic of South Africa ultimately revoked its withdrawal from the statute. Nevertheless, one can quickly see how the politics of deep unease has set in within some quarters about how the court has proceeded about its business in its relatively short life, its choices, its priorities, its decisions. On the court's own website of situations under investigation, the continent of Africa is cast in a blaze of blue, with only brief specks lighting up the grayness of the other continents. At the same time, however, let it be said that these developments are in matter of fact equivocal in the overall message they are sending to us, for they also suggest that the International Criminal Court is a thing of great value, that it has not been brought into existence in order to be dismissed, that it is worth fighting for. This explains why certain governments, I'm thinking of Uganda, of the Democratic Republic of Congo, Mali, Central African Republic, have approached the court with their referrals. It's in this political climate that I've just been discussing with you that the outgoing prosecutor of the court, Fatou Bensouda, announced in December of last year that she had concluded her preliminary examination of the situation in Nigeria and delivered her findings, which were expertly relayed by Ms. Balagaya. I do not want to spend the precious time allocated to me concentrating on the manifold technicalities. International lawyers love spending time on that, including on Friday afternoons. But it's worth observing that on the very same day as her announcement on Nigeria, the prosecutor concluded that the statutory criteria, again relayed by Ms. Balagaya, for the opening of investigations into the situation of Ukraine are met. And earlier this year, the prosecutor confirmed that her office had initiated an investigation respecting the situation in Palestine. So slowly but surely, and under her stewardship, we are beginning to see a more cosmopolitan docket of the court take shape. And I think it is helpful to revisit what Prosecutor Bensouda said soon before the start of her tenure. Real justice is not a pick and choose system. To be effective, to be just, and to have a lasting impact, justice has to be guided solely by the law and the evidence. Our focus is on individual criminal behavior and innocent victims. And equally compellingly, she also said the greatest affronts to these brutal and unimaginable crimes, women and young girls raped, families brutalized, robbed of everything, entire communities terrorized and shattered, is to see those powerful individuals responsible for their sufferings trying to portray themselves as the victims of a pro-Western, anti-African court. To return to the specific statement that Prosecutor Bensouda made in December 2020 on the war crimes and crimes against humanity of Boko Haram and splinter groups in Nigeria, she recognized in that moment that the vast majority of criminality within the situation is attributable to non-state actors. But there was also a reasonable basis to believe that members of the Nigerian security forces had committed similar acts. Referring to the overarching requirement of partnership and vigilance that must guide the approach to complementarity, she then spoke of her aspiration for the ability of the Nigerian judicial system to address these alleged crimes, reporting that some efforts, let me emphasize that, only some efforts have been made by the prosecuting authorities in holding Boko Haram to account, and that the military authorities had examined but dismissed allegations against their own troops. So the problem at hand is multidimensional, Prosecutor Bensouda is telling us, as there are challenges on both sides of the ledger where the performance of the states, its share of the deal regarding partnership and vigilance, have been found wanting and leave something to be desired. Nigeria may not be alone in this regard, it must be said, because a mere 2 years ago, graphic footage circulated on social media of armed uniformed men shooting 2 women with their young children on suspicion of affiliation with Boko Haram. The cautionary tale here is of the spiraling effect of violence, that violence begets further violence, and that states must tread cautiously if they are thinking of sacrificing the rule of law on the altar of convenience or impulse or expediency. What is to be done? What is to be made of the lackluster performance of Nigeria to hold perpetrators of either side to account for their actions? How and with what kind of precision is one to attend to the fine balance of complementarity intentioned by the statute of the court? Perhaps more of a sense of the realities on the ground will help illuminate matters for us. Just days after making her important announcement on Nigeria, Prosecutor Bensouda addressed the 19th session of the Assembly of States Parties, where she discussed the insurgency and counterinsurgency operations taking place in Nigeria, which have apparently resulted in the death of between 39,000 and 41,000 persons, including 16,000 civilian victims. Assuming these figures are even loose approximation of the truth, how do they comport with the resolve specified in the preamble of the statute of the court by each of the high contracting parties? And by each of the high contracting parties, I am naturally including the Federal Republic of Nigeria in the equation, to guarantee lasting respect for the enforcement of international justice. What meaning is to be accorded to these words if they are meant as more than mere rhetorical adornments? What deeds can be taken to demonstrate this resolve, this sacred guarantee? Even these statistics may not fully relay the extent of the problem that is taking hold of Nigeria, and which, by the account of the prosecutor, Nigeria has yet to take hold of. As will be known to this audience, just last month, 279 schoolgirls were abducted from their boarding school in Zamfara State. This came close on the heels of the Kagara kidnapping in Niger State in the same month, not to mention 344 schoolboys that had been abducted in Katsina State back in December. It is small wonder that these kidnappings have been described as a growth industry, and that the victims are now not just the rich, powerful, or famous, but also the poor, and increasingly school children who are rounded up en masse. They are the vulnerable ones who are in plain sight, made vulnerable again and again, depending on the nature of the response of both the domestic as well as the international legal system. The integrity of the rule of Nigerian law and in turn of international law are both at stake, and they are very much at stake under the watch of this esteemed assembly. What should that response be going forward? In a presidential tweet at the end of February, after the return of the Zamfara schoolgirls, President Buhari observed that state governments must review their policy of rewarding bandits with money and vehicles. Such a policy has the potential to backfire with disastrous consequences. States and local governments, he maintained, must also play their part by being proactive in improving security in and around the schools. This brings into full and appropriate view the multiple levels of the governance structure of the Federal Republic. But in so doing, it also marks for our attention the full role and record of the government in dealing with Boko Haram thus far. I put this on the table because a recent and very detailed study takes us back to the episode of the Chibok schoolgirls of April 2014 and intimates that ransoms were actually paid for their ultimate release, allegations that the government of Nigeria has, of course, firmly denied. But what then explains the growth industry, the burgeoning economy in captured school children? Why the multiplication of kidnapping since Chibok? Is it only state and local governments who should review their policy or policies, or should it be the policies of the Federal Republic itself? Aside from its firm denials, what statistics can the federal government advance as proof of its resolve for the law and legal processes? I'm coming to the end. Evidently, what is required is more than mere hashtag activism, important and fundamental, though this has been in alerting the world to and even affecting the plight of these school children. At a time when the continent is facing further turbulence with hostilities in Ethiopia and more recently in Mozambique, as we have witnessed most recently, the question for governments the continent over is whether they are prepared to make full use of the apparatuses of state so that they send an incontrovertible message to their people and to the world at large that international crimes committed on their territories will not occur without penal consequences. This message cannot be sent in a day, it cannot be communicated overnight. And it will take patience and perseverance to make clear that there is now a culture of accountability for one's actions, a culture built on the edifice of the rule of law. Please allow me to recall in closing that it was President Buhari who argued just over 2 years ago that with the alarming proliferation of the most serious crimes around the world, the ICC and all that it stands for is now needed more than ever in ways that were unforeseeable to its founders. These words are worth hearing again, and they are surely worth heeding. For there is really no reason why African states cannot imagine themselves as the authors of the future that awaits the International Criminal Court. Thank you.
Thank you very much, Professor Kritsiodis. You really honored us with a learned presentation full of content. If I can just say a few words before to give the floor to Amadi Ba, who is much more important than me. Let me just say that on behalf of PGA, we did our utmost possible to ensure that the Rome Statute system is incorporated and universalized in all regions of the world, not only in Africa. But I can tell you that the largest members of parliament joining PGA are from Africa, on their own will, on their own decision. We have more than 450 members of PGA in sub-Saharan Africa out of a global membership of 1,200. And they have been extremely active on essentially all the countries that you have mentioned. Just to say also, PGA also dealt with the issue of violent extremism. And here we must be self-critical if we can speak on behalf of people coming from this side of the world. I am a citizen of the European Union. And the use of violence in the name of counterterrorism against certain violent extremists. I'm here referring to the policy of targeted killings of certain elements of Al-Qaeda, ISIS, and other groups, as Boko Haram, has paved the way for the multiplication of this violent extremism. It didn't curb these movements. These movements are bigger now than they were on September 11, 2001, or other dates that you may wish to choose. Why? Because we thought that renouncing to justice and pursuing violence over violence could defeat them. It's not true. It's the opposite. It's helping them recruit more and more and more. So that's why we are here today, because I think our members of parliaments, and you can find in the Milan Forum of 2017, Parliamentarians of Global Action came up with a global plan of action on preventing and countering violent extremists that really does not fall under the, the hashtags stereotypes. But there is a lot of work to be done, of course, an immense work to be done. This gives me the possibility to introduce Amadi Ba, who is the head probably of the most important office in the office of the prosecutor vis-a-vis most of the situation countries of the world. Mr. Ba is a Senegalese judge with an incredible track record, and he's the head, and of course he's a former judge of the Cour de Cassation, just to mention one of his roles in the recent past, and he's the head of the International Cooperation Unit of the ICC. So he's the actual man who talks to state to gather their collaboration, without which the court cannot survive. So Honorable Ba has gave us the chance to hear from him many, many times, including in Kiev 2018, when we were holding our 10th Consultative Assembly of Parliamentarians on the ICC on the rule of law. So I just have to tell him, welcome back.
Thank you. Thank you very much, Mr. Secretary General Donat. Thank you, Honorable Speaker of the House of Representatives of Nigeria, Your Excellencies, dear colleague. I thank you very much for inviting the Office of the Prosecutor and having me in your workshop. First of all, allow me to apologize for my broken English, because I'm a Francophone speaker, and despite my reserve, but Donald wanted to have me, because being from West Africa and also heading the Department of the Section of International Cooperation. First of all, I was asked to talk about the importance of cooperation and to update you on 3 situations, Cote d'Ivoire, Mali, and Nigeria, preliminary analysis, examination. First of all, before giving my small overview of how cooperation is working and what are our results, what did we get in terms of results, especially when we engage with Africa, and what are our challenges, honorable speakers and members of Parliament of Africa have to know. I think it's good to remind the leadership role Africa have played to create the ICC. Today we have 120 states which have created the first international criminal court with a universal vocation. It means that with jurisdiction non-limited in time nor in space when seized by the UN Security Council. We have jurisdiction on crime against humanity, war crime, genocide, and crime of aggression. And what explains the rush Africa did in the past, Senegal was the first state to ratify, followed by these incredible, powerful countries, big politically and economically, playing a leadership role in Africa like Nigeria. Because we believe on rule of law, we engage ourselves to this court because Rome Statute have created a complete instrument to fight against impunity in the world and lasting peace. Why we believe on it, and we have believed on it. Nigeria, Senegal, and all these African states have played a big, big role in the implementation. And you see your delegate, your representative we met during the ISP are making a lot of reflection, constructive, critical, but very constructive reflection to advance the statute. Now, why cooperation? Because I was a national judge. I am until investigation judge. I'm not talking about cooperation when I implement my mandate as a national investigation judge, because I have police force that can enforce my decision. But here in the court, we haven't, except the decision of the judges who can address that to court, to the states. Nothing similar to what I had in the past in my national system is not in the Rome Statute. We canton states. It means the chapter 9 from Article 86 to 101 show how we depend on state, non-state party, NGOs, or international organization, UN, to implement our mandate. And you see, as the office of the prosecutor, we are doing the same job as a national judge, facing a crime to investigate. We need documents, we need testimony, we need forensic evidence, we need data evidence, we need to freeze property in order to advance, to get real and realistic evidence to bring to court. And at the same time, we are depending to states. My colleague Balagay have told about preliminary analysis, which is the first phase. Even at that phase, we depend on state. I give an example. Last year, from August 2019 to May 2020, we have received 61 communications from victims, NGOs, states about crime committed in the war. And we assess these documents to see if we have jurisdiction. I will not come back to what he said already very clearly. Is it admissible, this crime? Are they admissible? Because of complementarity with ours, we are a court of second resort. We encourage states to take the case, to investigate. I can tell we interact with the government of Nigeria since 2013. We began our investigation, our communication received in 2009. We make public the PE on 2010, and since 2013, we engage at all levels with the Nigerian government. We invite to investigate. We invite you to investigate. And if complementarity is not observed, if the crime are enough grave and interests of justice justify we open an investigation, we do it. Now, while we have created new investigation, we get new investigation from this communication, Venezuela, Bolivia. We have completed 4 investigations, as told the professor and my colleague, Palestine, Iraq, UK, Ukraine, and Nigeria. Following this coup, do we have jurisdiction? Is these crimes, are there enough, are they admissible following complementarity and gravity? Interest of justice justify we open an investigation. You see, in that case, we have to cross-check the information we receive with the state, officials, NGOs, and we need cooperation even at this stage. During our investigation, when a team are deployed out of The Hague to collect evidence like a national judge, we all also need cooperation by 2 tools. We send a request of assistance to the state, assist us to get this document, to meet this witness, which is military or officials, or accept our mission because we don't need any assistance. We just need your consent to collect evidence because you are state party, and we have signed an agreement. 2 tools allow the office to investigate. And if you take what we did since just 1 year, 66 to 1 communication, completed 4 PE, open new Venezuela, Bolivia, investigated since then. If I give you statistic, since this period, we have sent RFAs investigation requests to 95 partners around the world. Among them states like Nigeria, other countries, non-state party, and NGOs. With 95 partners mean 485 requests we have sent in less than 1 year of investigation. But when I give you this statistic, what did we receive as? Because cooperation is on both sides. State send us requests for information also to get evidence. It's why we share a space. We don't want crimes, but when it happen, you have obligation and we have obligation. How could we discuss to share this? Do you want to take them, like my colleague said, for Guinea? Yes, we support, we evaluate, we follow up until you open investigation about the serious crime and against the serious responsibility. We did not hear us talking about investigation in Niger, in Guinea. We are talking about PE because the government have shown leadership, willingness, and capacity. And we follow and we accompany the government. We have also, among these 45 requests, we have received from the state 30 requests of assistance because in Republic Central Africa, in Mali, in other countries, they also share with us a space, unfortunately, of crime to fill the gap of impunity. They play a role. In CAR, you are playing a role. Special court created are playing a role. National court are playing a role. And we are coordinating to fight against crime in impunity in CAR in a very coordinated way because they make requests and we give them information we have. I can multiply the example. Each situation is unique. Each situation is different in terms of cooperation. But when you have these numbers, this statistic, especially in Africa, what you can tell is cooperation is going very well. Despite every political dynamic, the operational work is going well, and Africa is supporting the court in an incredible way. But success of a court is not just statistic. It's what impact do we have in the national system. It is not the numbers, because the numbers of cases can show that we failed to implement complementarity. We have to think about that the success of this court is not just giving statistic of a good cooperation we receive, but having less case because states are doing the job. But despite the success we have a lot of challenges, and I will conclude on this chapter about the cooperation challenges. Some challenges are operational, others are political and diplomatic, others are just technical, linked to lack of resources, and the fourth one are more specific to our request because of the new environment of criminality. The operational, you know, in Nigeria, our focal point is the Attorney General. He's Honorable Attorney General, Minister of Justice of Nigeria. We have a political focal point in each country. In Senegal, it is the Minister of Justice, but the embassy is our first entry. Other state, it is the Minister of Foreign Affairs. You know, with each country, we have a framework how we can implement our cooperation. With Nigeria, and we thank also the authority of Nigeria since 2013, we are having mission, interaction, and we hope this will continue despite that the conclusion I will give later. We have a security challenges because in some countries like CAR, we have access on Bangui, but we have not access to the other territory because of lack of security. But what did we do in terms of cooperation? We opened the neighboring country because displaced people are there and we can get evidence and witness testimony from these people. Each situation is different. We have political difficulties with some states, not difficulties, but challenges. We have 14 arrest warrants which are not executed. We have also implementation of legislation, despite the efforts done by PGA, and I give them this leadership and thank them. Some states are still now did not domesticate Rome Statute. We have tension between peace and justice. I understand a politician, which is elected, who want to bring peace, but at the same time, we always tell to the office, let's talk, because what we do in justice can be adapted to do your peace process while we bring justice to victims at national, international, or national level. It's just a coordination work we need to do. We have some technical challenges, which is resources, also a focal point changing in our country because a lot of politics enter in, the ministers are changing. The operational focal point we use to talk and train and talk and show engagement, and our offices have sometimes changed and it's difficult to find someone to replace. If they are replaced, it takes a lot of time because this person understands. And the focal point have not the resources, etc. We have to fight for the country to give to the focal point a lot of resources and team to help us. We have also some new challenges which link to what? We need military information. We need financial information. We need novel technology of data, phone information. And my colleagues from investigation division are doing all their best to follow up this data collection, but we have in military information, but we have a lot of challenges from states to give this information. It could be very helpful to get them. It could fasten the investigation, shorten the investigation, but we have a lot of problems related to this. To conclude on the cooperation, it's very good. It's not because I'm heading the section, but the overall result I give you, if you tell me what country, I will tell you with whom we talk and what miss and what we have to improve at political, diplomatic, and operational level. What FATU have brought since her election is engage Amadi, collect engage with respect, with optimism, anticipation, be proactive. Please be flexible. We respect the state because they set this court and we have to listen to them. And since we are doing that, in 9 years, we have succeeded a lot of results. Now, to conclude briefly on the 3 cases. Bagbo was released and Blegude by the trial chamber. We appeal, and the appeal chamber confirms the judgment. The first was 2 judges, 1 out of 1, and in appeal, 3 judges out of 2, but it is a majority, confirms that they are not guilty and they are innocent. And as a judge, as a member of the court, member of OTP, we have a great respect on the judges and their decision. Let me just tell you, we have brought 82 witnesses physically by video link or visual link. 231 hearing day, thousands of documents, 77% was granted quality of victim. But at the end, judges are the only one here to control what people are doing. And we are reading the decision to do a lesson learned, to access where we are seen as having failed. On Al-Hassan was transferred in 2008 for crime, against humanity, war crime, as his alleged member of Ansardin, de facto chief of Islamic police. He was involved, according to what we have as a charge, because the trial is going on. I have to respect the presumption of innocence, that he was supposed, according to us, member of the police Islamic group and the Islamic court. And the presentation of our evidence is going on. Nigeria, very quickly, we make public the PE on 2010. We engaged with the government on 2013 after having a lot of interaction. And since then, we have created a cooperation focal point from the embassy and the Ministry of Justice. As said my colleague, we have ended the assessment and conclude the PE because determination have been done that criteria to proceed with an investigation are met with respect to jurisdiction, admissibility of interest of justice. And as you have seen, to be frank, and I send you, look at the report of 2020. The scale of violence is unprecedented since 2009. Boko Haram insurgencies and its splinter group counter-insurgency by the Nigerian security force have created approximately, have said the professor who was talking before me, 39 victims killed, killed, between 39 to 41,000 persons killed, including 16,000 civilian victims. For our biggest country, we respect, playing a leadership role politically and economically in West Africa, where we are very proud of Nigeria. And in Africa, it's a very difficult situation we are facing internally, even my boss. Both sides, crime have been committed. Now, what to do? FATU have consulted with the new prosecutor coming on the strategic and operational issue related to the prioritization of the OTP workload and filing of necessary application before trial chamber. He can't decide alone, he involves the new prosecutor. In the interim, the situation is not suspended, is not hibernated. It's not an investigation, it's an interim period of pre-investigation, where measures are being taken to ensure the integrity of any future investigation before the coming prosecution. Now, what to conclude on this situation? We hope, because of the leadership of this country, not only in Africa, but around the world, to continue to engage with its authority, to get full support of Nigerian authority. OTP and Madam Bensouda and the new prosecutor is looking forward to a constructive exchange and cooperation of the government to determine how justice may be best served under the shared framework of the complementarity, domestic and international action. As you see, the door is open. I explain you many cases like Guinea. I give car situation. I can multiply the example to show you that each case, each situation, each investigation is different. It depends on how we engage and how we want you to engage. And you want, how you want, what you want, what is your vision for this crime? But the fact of keeping silence is the only thing we have to avoid in such situation. Thank you very much.
Thank you very much, Amadiba, because you always engage with us in such an interactive way. And I see that in the chat, there are a number of reactions. I think if I can comment on complementarity, I think the office has done really more than what even the drafters of the Rome Statute envisaged. As a lawyer, I don't like to think about or to mention positive complementarity. For me, it's only complementarity that exists, but I must realize that your office has done a lot to engage and work with states on ending the impunity gap. And however difficult it is, it's an engagement that is worthwhile to be undertaken, because here we are, the goal is really to reduce the victimization of innocent civilians anywhere these atrocities are committed. So any domestic effort that would meet the threshold of complementarity, which is that there shouldn't be sham justice, that there should be willingness and ability to end impunity, well, under the Rome Statute, then every state has the should have the capability to do so, unless, of course, they are absolutely collapsed and unable to produce results in this field. This brings me to the first parliamentarian speaking from outside Nigeria today, Honorable Fatoumata Ndiaye, who is a member of the National Assembly of the Gambia, member of the Standing Committee on Human Rights and Constitutional Affairs, and also member of the ECOWAS Parliament. And in this respect, I want to stress here that we received a message of support yesterday from Honorable Tunis, the Speaker of the ECOWAS Parliament from Sierra Leone, who is also a PJ member, couldn't be with us today because he's currently traveling, but he sent us a message of very strong support. Honorable Ndiaye will speak about accountability for mass atrocities through the implementation of the Rome Statute in the national legislation, having in mind the example of the Gambia. Honorable, I am pleased to give you the floor.
Thank you very much, David, and good afternoon to my fellow parliamentarians, and a special greetings to my sister, Horeja Balagay, whom I'm very pleased to see in this gathering today. She's really made us proud during her deliberations at the TRRC, and we actually miss seeing her daily contributions. My name, as I was introduced, is Honorable Fatoumata Ndiaye, a Gambian parliamentarian sitting both at the Gambia Parliament and at the ECOWAS Parliament, and also a member of the Human Rights and Constitutional Matters Committee in the Gambia. And it is with great humility and pleasure that I am opportune to speak in this auspicious forum, which I think cannot come at a better time, considering that Gambia is at the process, at a TRRC, which is the Truth, Reconciliation and Commission process, and that the Parliament and in extension, my committee is considering the status of the international crimes and prevention and prohibition of torture bills, respectively, in view of domesticating the Rome Statute of the ICC. And actually, the Gambia ratified the Rome Statute since 1998. It is only a matter of domesticating. And with the type of government that we had, obviously somebody, I think Dr. mentioned that Gambia at a stage initiated their withdrawal of the IEC, which after 2016, our government revoked and are happy to be part of again. I would first of all start by giving an overview of the objects and reasons of both of those important bills, starting with the International Crimes Bill, which is aimed to providing for the implementation of the obligations assumed by the Gambia under the Rome Statute of the ICC, and also for the punishment of international crimes of genocide, crimes against humanity, and war crimes. It will also enable the Gambia to cooperate with the ICC in the performance of its functions, which I have had various speakers mention the importance of, especially Amadiba of the ICC. And I think we are more than ready now looking at these bills that we are working on. Even though it is taking longer than necessary, I think this is very apt that we do our due diligence to ensure that when it comes out, even though it might not be perfect, but it will reflect the needs of where we are now, considering the TRRC, because Horeja mentioned some of the challenges that the TRRC experienced, and I took note of those challenges, and I would ensure that they will be reflected in these laws that we are making, because if we make laws that do not reflect the needs of the nation, then there is no need making those laws. And the objects of the International Crimes Bill would give the force of law in the Gambia to the statute, which I think would be very welcoming, and implement obligations assumed by the Gambia under the statute as well, making further provisions in the Gambia's law for the punishment of international crimes, and to enable the Gambia to also further cooperate with the ICC in the performance of its functions, including the investigation, prosecution of persons accused of committing crimes referred to in the statute. And it will also provide for the arrest and surrender to the IEC of persons alleged to have committed crimes referred to in the statute. It will also provide for various forms of request for assistance to the ICC, and it will also enable the Gambian courts to try, convict, and sentence persons who have committed crimes referred to in the same statutes. And I think when we talk about prevention, which I will go to the second bill that I was asked to look into, the objectives of the Prevention and Prohibition of Torture Bill is to provide the legal framework for the prohibition, prevention, and punishment of any form of torture and cruel, inhuman, or degrading treatment in the Gambia. In the Gambia, I mean, we have seen a lot of degrading and inhuman treatment in the past 22 years prior to 2016, and lessons learned must be factored in the laws that we make to make sure that we prevent. But like Horeja Balagay mentioned, there were some challenges, and if we are looking at preventing and prohibiting torture, we must also look at the protection of victims, because without protecting them, they might not come forward to be able to give us the information that we need. So I especially took note of what she mentioned when she said that the challenges were to witness protection framework, witness support, and most importantly, the psychosocial support and the lack of expertise in the country. So I think provision must be made to ensure that we cater for those needs. And being a lawmaker, we are also responsible for the budget. And I would also make sure that there are budgetary considerations when it comes to those. And that is one of the reasons that I am very glad to be a part of this. And in the Gambia, for now, both bills have been considered the first and the second readings. And hopefully in the next sitting in June, we've had to ask for extension because we were not ready in our investigations. And I think this information that I've received today will be very important, and I will take it back to my committee so that we can consider some of the information that I've gathered here. And because it will be going to the consideration stage, the third reading, and subsequently the consideration stage in June. It had been identified in the Gambia. There are no specific statutes of laws criminalizing torture. And that is a very important thing to note, because it came to our attention during the TRRC that torture was not recognized in the laws of the Gambia. And that was very disheartening, considering the amount of torture, the amount of inhumane treatment that the people of the Gambia have been through in the past 22 years prior to 2016. And for our experts and for the laws to come and the government to come and tell us that it is not recognized is totally disheartening. So I think these bills are apt and we need to work on them and make sure that they are catered for, at least to consider the plight that our victims have gone through. And working with the TRRC and the Human Rights Commission, the National Assembly and the government of the Gambia think it is necessary now to look into these lapses and the need to address the omissions and make sure that they are catered for in the laws that we are making. And many a times there have been public outcries as to the accountability and the liability of perpetrators of those hideous crimes to no avail. It was thus incredibly apt and unprecedented in the Gambia that the Supreme Court, in one of its recent judgments regarding the case of Yankuba Toure and the state, clearly stated that immunity cannot be used to shield oneself from crimes against humanity or torture. The accused was indicted for allegedly murder in contrary to Section 187 of the Criminal Code, Cap 10, Volume 3 of the Laws of the Gambia. And the counsel of the accused leaned on the grounds that as a former junta member from 94 to 97 and pursuant to paragraphs 13, 1, 3, 4, and 5 of the second schedule of the Constitution of the Gambia, the accused enjoys immunity from such prosecutions. And it was very apt and it was very welcoming and unprecedented that the Supreme Court decided against that, and the court is actually proceeding with the accused still in jail, of course. And in the view of addressing and filling the gaps in our domestic legislations, the International Crimes and Prevention and Prohibition of Torture Bill was presented to the National Assembly in 2020 for consideration and scrutiny. And we are, like I mentioned, the first and second reading was done back in July 2020. People might say it is taking longer than necessary, but with these kind of bills, we cannot just work on them haphazardly. We must take our time, do our due diligence. And in fact, in January, we went on a retreat. My committee, the Human Rights Committee, went away for 10 days, thoroughly looked at it, page by page, close by close, line by line, looking at where lapses were and what we needed to add, considering the situation of the country, bearing in mind mostly the TRRC and things that have happened in the last 22 years prior to 2016. We've compiled our report, and we are still working on it. And in fact, the committee is meeting on Monday to look at it so that we will prepare the final draft and lay it at the plenary. And as representatives of the National Assembly, we have also been informed of many more gross human rights violations, with victims mostly being women and children, who are the most vulnerable. And to that regard, we are fully committed to seeing those bills progress at National Assembly level, particularly bearing in mind those vulnerable people. And the Human Rights Committee is also fully devoted to see that impunity of mass atrocities are regulated by ensuring that all human rights and international conventions and agreements are ratified and on time, and not only ratified, but domesticated as well. These would be complemented, continuously enlightening citizens of their rights, as well as encouraging honorable members to swiftly work on enacting any necessary bills to protect their representatives. At times, though, we would want to work fastly, but we also need to do our due diligence, like I said, to ensure proper and effective laws are passed to comply with international best practices and other conventions to be taken into considerations. And these are some of the reasons why these laws drag in Parliament, to the point that we request for extension and proper scrutiny. And the Gambia we want are the laws that we are going to make, not only for us, but for generations to come. And we are glad. And what I am taking away from this meeting today will be transferred to the Human Rights and Constitutional Matters Committee. And we will definitely make sure that we do not only work on these bills, but also work on any bill that would protect against impunity. Thank you very much.
Thank you very much, Honorable Fatoumata Njai. And I didn't mention that you are also a member of PGA, so I think your speech made us very proud of having you with us. And next Monday, it's an important day. We really look forward, whenever you will be ready, to read your fantastic report on behalf of that you're writing on behalf of your voters and the people of the Gambia. I would like really to ask everyone to be as short as possible in their presentation, as we are a little bit behind the schedule. We were thinking of a 15 minutes delay anyway, but no more than that. And you referred, Honorable, to the importance of gender-based crimes and how they are affecting deeply society. So we have here a commentary on this important issue that is being shared with us by Miss Priya Narayanan, I hope I pronounced her name correctly, who is a member of the Office of the Prosecutor, but at the level of appeals. She's an appeals counsel from the ICC. Priya, please take the floor.
Thank you very much. Good afternoon to everyone, distinguished members, honorable members, distinguished ladies and gentlemen. Thank you very much for inviting me. It's a great pleasure for me to be able to address all of you. And I must say, I feel very fortunate to follow such excellent speakers. I really enjoyed listening to each and every one of you before me, and I'm sure I've learned a lot from that as well. So yes, I am an appeals counsel, and I work, of course, within the prosecution division of the Office of the Prosecutor. And I also work closely with colleagues to ensure the implementation of the prosecutor's policy on sexual and gender-based crimes, which brings me exactly to the topic that I've been asked to address today, which is the importance of the gender perspective within the Rome Statute and within ICC jurisprudence. I'll be as short as I can, bearing in mind the time. It's also a thematic approach that I'm taking, and obviously I'll approach it from the perspective of the Rome Statute, but I hope that it will be useful all around. Well, I mean, as you know, the prosecutor has a special policy on investigating and prosecuting sexual and gender-based crimes, and it is a priority for her, and I'll certainly touch upon that. But as the starting point for anything related to gender, that really must be our statute, which is the Rome Statute. And as you know, it does have a special role to play in prosecuting these crimes towards ending impunity for them. And in that respect, the statute does introduce very many innovations in international criminal law, and I'll try to touch upon some of them. The first, of course, is that the statute itself defines the term gender. And Article 7.3 of our statute says that the term gender refers to males and females within the context of society. That phrase, within the context of society, was, I believe, the subject. The definition itself was subject to great negotiation at the time of drafting. But ultimately, the definition is a compromise, as most good things are. But it's also broad enough to capture both the biological aspects as well as the sociological aspects of gender. And it does inform the perspective that one takes to these crimes in the statute and within the Rome Statute framework. Now, the statute itself has a very wide scope to investigate and prosecute sexual and gender-based crimes. Now, some of them, as you will see, is really as listed in the statute. And as I said earlier, there probably are several new approaches and several new, well, relatively speaking, crimes as well within the statute. Now, for instance, if you look at, for example, and since we're speaking very specifically on, the concept of gender, if you look at the notion of persecution as a crime against humanity under the statute, it lists very specifically gender as a ground for discrimination or targeting. Now, this is itself somewhat of a progressive development, taking the work of the ad hoc criminal tribunals, the ICTR and ICTY, forward. Because as many of you know, while persecution was a crime under the statutes of those tribunals, they never listed gender as a specific ground, while the Rome Statute does that. Now, what does this mean? It just means that it has potential for investigation and prosecution. So gender persecution could include situations that discriminate on the basis of biological sex, but also based on socially constructed gender roles. So just to give you one example, in the Mali situation, in the Al-Hassan case, which my colleagues have already referred to, and incidentally, that's the first case where we charged gender persecution, and that's currently at trial. The chamber noted that gender persecution could exist when men and women within the same group were treated differently or subject to different forms of violence. So a classic example of that would be when women are subject to sexual violence and men are, for example, killed. So that's just one example, but obviously there's much more to discuss and develop on that itself. Now, coming to the list of the crimes under the statute that could potentially be helpful, the statute itself, of course, covers rape, sexual slavery, enforced prostitution, enforced sterilization, forced pregnancy, and also a catch-all, which is any other form of sexual violence, which is of comparable gravity. Now, when we turn to rape and sexual slavery, that has been somewhat, comprehensively developed in the case law of the court already. And I can say that, as recently as 10 days ago, on the 30th of March, 2021, the appeals chamber confirmed, or rather upheld, all of Bosco Ntaganda's convictions, which were entered at trial. And that's, of course, in the DRC situation. And that includes for counts of rape and sexual slavery, both against civilians, men and women, but also for individuals under the age of 15 within the UPC FPLC group itself, and also confirmed his sentence of 30 years. Now, in that respect, I think what may be interesting to note is that the Ntaganda trial chamber, whose findings have now been confirmed on appeal, did note that acts of sexual violence, like the killings and other acts of physical violence, was a tool to destroy the Lendu community, which was the community under threat in that particular situation. So those are all important findings. Again, I think also to note a more recent development, the Ongwen trial chamber also convicted Dominic Ongwen for several crimes relating to sexual and gender-based crimes, including rape and sexual slavery. But I must emphasize that those convictions were entered at the trial phase. There is most likely an appellate phase to follow. Similarly, one of the, I think, quite novel crimes within the statute is, of course, that of forced pregnancy. And this is, relative innovation within the statute itself. And it covers a situation. I'm sorry. If I may continue. It covers a situation where a pregnant woman is unlawfully confined, either with the intent to affect the ethnic composition or to carry out other grave violations of international law. And again, recently the ongoing trial chamber entered convictions at the trial phase for that crime. And in doing so, it recognized that the crime of forced pregnancy is particularly one that recognizes a woman's right over her personal and reproductive autonomy and a right to have a family as well. So in that sense, I suppose it could be categorized as a reproductive crime. So it's a very specialized form of sexual and gender-based violence. Similarly, we also have forced marriage as another inhumane act, and some of my colleagues have mentioned that in other contexts as well. Now that's been charged in the Al Hassan case again, that's in the Mali situation, currently at trial. But the ongoing trial chamber has also entered a conviction with respect to that at the trial phase. And what's important to note is that the judgment recognizes that the crime relates to a unique harm, which is not necessarily captured by other crimes such as rape and sexual slavery. And that harm is specifically relating to the imposition of the status of a forced conjugal union upon the victim, along with all the associated apparent duties that may come with this so-called marriage. So again, that is almost a separate crime, if I can call it that. We also, of course, have enforced sterilization, enforced prostitution under the statute, but these are still to be addressed by the judges and by the court. Now, in addition to all, what we may traditionally understand as sexual and gender-based crimes under the statute, we have other crimes as well, which may not traditionally lend themselves to that notion, but very often in our cases have or reflect those components as well. So some of those would include crimes of torture, cruel treatment, outrages upon personal dignity as a war crime, enslavement, etc. So just to say that the scope to prosecute these crimes under the statute is quite vast. So it's a question of a potential in terms of using the statute to its best ability. But of course, it would necessarily have to follow the evidence in every individual case. And lastly, just very briefly to turn to the prosecutor's own policy. I don't think that any discussion on sexual and gender-based crimes and the gender perspective under our statute would be complete without mentioning the prosecutor's own policy and her priority. As you know, the policy was brought in June 2014 with a specific view to enhance the investigation and prosecution of sexual and gender-based crimes. Now, some of its key features, I won't list them all, but very briefly. One is that it recognizes sexual crimes and gender-based crimes. So they're really two different categories of crimes in a way. Sometimes they may overlap, but they can also constitute their own individual categories. Both sets of crimes can be committed against all persons, including men and women. So, the category of victim is broad. Gender-based crimes do not always manifest as sexual violence, so you could have non-sexual attacks based on gender. Similarly, sexual crimes do not always manifest in physical violence. So one example of that is, for example, forced nudity, which may not necessarily match our traditional understandings of physical violence, but it is a sexual crime nonetheless. The policy also recognizes that this category of crimes are among the gravest under our statute and required to be investigated and prosecuted with every seriousness. And in that respect, all of us are required to pay attention to these crimes at all stages of our work. So that starts from the preliminary examination to investigations to prosecutions, trial, post-trial, sentencing, appeals, reparations, and essentially we're meant to bring a gender perspective to our work at all these stages. So with that, I'd like to conclude and thank you very much for your very kind attention. And of course, if you have any questions, I'd be more than happy to answer them. Thank you.
Thank you, Priya, for the very, very clear presentation. We now have a final speaker on behalf of members of parliament. We are honored to open for the first time the floor to Diputado João Bernardo Vieira from Guinea-Bissau. Welcome to PGA, Honorable, and you will speak about the universality of the Rome Statute, as Guinea-Bissau, together with Togo, are the only two countries in the ECOWAS that didn't join yet the system. Honorable.
Thank you so much, Mr. Secretary General, distinguished colleagues, parliamentarians. I would like to begin by thanking the experts who spoke in the previous panels for their very comprehensive panorama on different aspects of the Rome Statute and how the universality and implementation of the statute can strengthen the domestic legal framework. It is indeed paramount that states ensure that they have the pertinent legislation in place to investigate and prosecute international crimes. In that sense, legislators are key actors. It is, let me say that it is an honor to address for the first time you today and say a few words about the opportunities to further the universality of the Rome Statute by actively working toward the ratification of the statute by my country, Guinea-Bissau. As you know, 13 out of 15 states in the ECOWAS are state parties to the statute, which makes universality in the ECOWAS almost a reality. Only Guinea-Bissau and Togo are not state parties. As you know, my country was embroiled in political and institutional crisis since August 2015. Parliament only reopened and resumed its work on April 19th, 2018. Although parliamentary elections had been set for November 18th, 2018, the mandate of the legislature was extended to accommodate a new date. Due to logistical and financial challenges, the elections were pushed and held on March 10th, 2019, with the strong support of the ECOWAS and other partners. The new legislature was inaugurated on April 18th, 2019, and a power tussle between political parties over the composition of the Bureau of the Parliament, which is the organ responsible for managing parliamentary affairs, became a new source of conflict, stalling the formation of the government. Noting that an impasse was not unexpected in the parliament, the political actors were urged to finalize the composition and installation of the Bureau of the Parliament in conformity with the outcome of the elections. Today, my colleagues and I at the National Assembly stand ready to work towards the ratification of the Rome Statute and its full implementation. We as legislators have the primary responsibility and competence to deliberate on the ratification of international instruments, as well as to consider, discuss, and adopt legislation to reinforce the domestic legal framework in accordance with the Constitution. One of the main pillars of the Rome Statute system is complementarity, which means that states are primarily responsible for investigating and prosecuting international crimes. It is thus in my country's interest to ratify the Rome Statute and also to fully implement it. The government and the Parliament of Guinea-Bissau should ensure that the ICC is truly universal by removing legal and political obstacles to the ratification process in the country. To achieve such ratification, as other Lusophone countries such as Brazil, Cape Verde, and Portugal, Guinea-Bissau should consider to start a procedure towards a modest constitutional amendment, which is, according to Article 127 of the Constitution, the prerogative of the National Assembly. In this respect, the Constitution of Guinea-Bissau has similar provision to the Constitution of Brazil, namely the prohibition to extradite nationals abroad. But this prohibition should not be interpreted as a main problem to join the ICC system, essentially for two reasons. First, if the ICC may need to request the transfer or surrender of Guinean nationals, Guinea-Bissau will not be requested to extradite them to the ICC, but just to temporarily transfer them for the purpose of trial proceedings in The Hague, which means that the same individuals may be retransferred back to Bissau. Second, the ICC jurisdiction is only complementary to the jurisdiction of the state parties. In the context of my country, Guinea-Bissau should use this opportunity of the external stimulus as represented by the possibility of the ICC intervention to make sure that its judicial system will be reinforced to the point that it will be able to prevent and counter impunity in the future, should international crimes be committed in Guinea-Bissau or by our nations. By doing so, we will provide to our people a guarantee of never again in respect of the perpetration of atrocity crimes, and we will have honored our legislative mandate in the service of the rights and best interests of our people. My colleagues and I, with the technical assistance of the Parliamentarians for Global Action, PGA, will work on an amendment proposal which will help galvanize colleagues and foster political will to come to a multi-party agreement around specific and tailored amendments. In 2009, PGA provided technical assistance to the Cape Verdean Parliament and contributed to the efforts towards the adoption of the constitutional reform necessary to accept the ICC jurisdiction. The protection of human rights and strengthening of the rule of law is not a partisan matter. It benefits us all and humanity at large. It is time for my country to participate actively in the prevention of international crimes by ratifying the Rome Statute and by having the necessary domestic legal tools to investigate and prosecute said crimes by implementing the statute. It is time for Guinea-Bissau to take these steps. I thank you, Mr. Chairman.
Thank you, Honorable Vieira, and we are really, really grateful for your determination and look forward to work with you and your colleagues. This brings us to the last expert in the list, but I know that some of you have made important questions. I see, for example, two questions from Chairman Namdas addressed to Amadiba and Professor Dino Kriziozis. So I would kindly ask them to look into the chat to address those questions right after my colleague Frederica Shriko-Verova will address the issue of the role of parliamentarians in this campaign. And Frederica, I think we are out of time, so you should be as fast as you can in your remarks. Thank you.
Thank you very much. And it is my pleasure to contribute to this conversation, especially after hearing all these inspiring and important expert exchanges. So given that we've heard about the situations under the focus of the ICC and also the steps that the countries have taken to address these crimes, I would like to touch upon the role that parliamentarians can play. Of course, we have already talked about their role in the advancing of the ratification of the Rome Statute and its amendments, but I would specifically like to touch upon the implementation aspect. And just briefly, aside of basically both of these roles, parliamentarians can also play a very important role in advancing the signature of bilateral cooperation agreements with the ICC, and also the ratification of agreement on privileges and immunities of the ICC that facilitate the conduct of proceedings and cooperation with the ICC. So in my presentation, I will focus in particular on the aspect of which elements such implementing legislation should contain, and briefly touch upon some of the benefits of having this legislation in place. So as to the elements, the most important parts of the implementing legislation are the definition of the core crimes and general principles of international criminal law. So as we've already mentioned some of the crimes, let me just reiterate that there are 4 core crimes under the Rome Statute, which are genocide, crimes against humanity, war crimes, and crime of aggression. So parliamentarians can introduce bills that amend their domestic penal codes to include these crimes in line with the provisions under the Rome Statute. Particular emphasis should be placed on sexual and gender-based crimes, as had already been explained in more detail by Ms. Priya Naranayan. And while states are encouraged to adopt provisions even going beyond those under the Rome Statute, we consider the Rome Statute serves as a very good benchmark as it codifies and furthers the customary international law. In this respect, I would just like to mention some, perhaps an example of some of the ECOWAS countries. So some of them have implemented genocide and most war crimes, especially through implementing the Genocide Convention and the Geneva Conventions, and in some cases also its additional protocols. However, this leaves out some of the very important crimes, including crimes against humanity. Whereas some other states, for instance, let me just mention Côte d'Ivoire or Senegal, have adopted more comprehensive legislations which align their criminal codes fully or almost fully with the Rome Statute. I will move to the principles. As I mentioned, there are general principles of international criminal law, and these are applicable particularly to these core crimes. So while there are several, I will focus in particular on 2. So while the Rome Statute includes several modes of liability under individual criminal responsibility, there is another specific type of liability, the principle of command responsibility. And under this principle, commander is responsible for crimes committed by their subordinates, so let's say soldiers in the field, even if the commander did not share the intent to commit the crime or did not possess the actual knowledge about the crimes committed. So in fact, the threshold of knowledge is that the commander knew or should have known about the commission of the acts. It is crucial to incorporate this principle correctly. An inaccurate definition may lead to unjustifiable acquittals of commanders who are the ones who have the primary role to guarantee that the conduct of the soldiers in the field is in full respect with international humanitarian and criminal law. Another principle I would like to mention is the non-applicability of immunities. So the liability for these grave crimes that we discussed already should apply to everyone, irrespective of anyone's official position. As such, legislation should exclude the applicability of immunities to high-ranking officials, including the president, as these immunities basically shield them from the execution of the arrest warrants and subsequent criminal proceedings for these grave crimes. The implementing legislation could also expand the jurisdiction to entail universal jurisdiction. And under this type of jurisdictions, the state authorities are basically empowered to try perpetrators who committed crimes which are not related to that state, territorial, personally, not even through another link. And this provision prevents these perpetrators of these grave crimes from seeking refuge on the territory of that state and using it as a safe haven. It does serve as a safety net, which closes the impunity gap in those cases where no other state would exercise the jurisdiction, so the perpetrator would otherwise go free. Universal jurisdiction is included in several international instruments, for instance, in the Geneva Conventions and also the Convention Against Torture. And let me just briefly mention one of the very significant cases where the state applied this type of jurisdiction. And that was the trial of the former president of Chad, Hissène Habré, who was tried by extraordinary African chambers, which was established within the Senegal court system. Now we'll just move briefly to the importance and benefits of implementing legislation. So not including the crimes or main principles of international criminal law in domestic legislation could result in the ICC assuming its jurisdiction over the situation. And as the principle of complementarity has already been discussed in great length by other panelists, I would just like to mention that depriving states of this opportunity to try cases in their domestic jurisdictions is not only not beneficial for the cost and also time perspective, but also enabling them to try these perpetrators in their own jurisdictions is the most effective way how to advance the fight against impunity. These trials are closer to victims and affected communities, and also are more efficient from the perspective that the evidence gathering is, of course, much more practical and also much more feasible. Another important advantages that I would like to mention of the implementing legislation is that it's not only specifically related to these 4 crimes where the domestic legislation can actually benefit from having these provisions in place. This implementing legislation can also have a bigger impact on reinforcing the rule of law in the country. So in particular, having these provisions in place reduces other phenomena such as corruption, drug trafficking, political violence, and other crimes, which prosper when the rule of law in the country is undermined or when the impunity prevails. It also strengthens victims' rights and rights of accused, and guarantees that fair trials are conducted not only for international crimes, but also for all crimes prosecuted by the state. And let me just mention also the example which was already referred to by Professor Christiosis and also Justice Amadi Ba in relation to Boko Haram. It's also in the context of these trials where having in place an adequate legislation, which also covers crimes against humanity and war crimes, is more adequate and suitable than trying the perpetrators under anti-terrorism laws, which do not sufficiently cover all the elements which are necessary to address these crimes. And this is important also for the rights of accused and also from the perspective of legal certainty. And it's exactly the legal certainty, which is another important aspect, which basically needs to be highlighted when we speak about the implementing legislation. When it's detailed legislation indicates which behavior is to be avoided, which is very important for predictability, and inevitably, it also leads to deterrent effect. I would just like to mention one perhaps important note, which is as an incentive for the states or additional incentive to adapt the legislation. Sometimes there is a lack of resources which may be considered as a potential hindrance. Not only we would, of course, be then ready to assist in any preparation of these laws as our PGA Secretariat, but also states are eligible to benefit from the support of the EU financial instruments. For instance, the European Development Fund, which contributes to supporting complementarity activities in beneficiary countries, including in Africa, in order to boost the fight against impunity through the reform of the relevant domestic infrastructures. And let me just conclude by emphasizing that each country should aspire to the highest level of human rights protection. This not only serves as a strong deterrent factor, but also demonstrates that the country is at the forefront of the international criminal justice. And parliamentarians have a key role to play in national and global efforts to promote and protect human rights, democracy, and peace. And this is in their capacity as lawmakers, in their government oversight functions, and also as democratically elected representatives of the people. So we strongly encourage the parliamentarians to use their mandate to ensure a high level of human rights protection to their constituents through implementing the Rome Statute domestically. And let me just reiterate finally that PG Secretariat has already contributed to adoption of the legislation in 37 countries by providing technical assistance. So we would be more than happy to assist any other states in this regard. Thank you very much.
Thank you very much, Frederica. And I think we have exhausted with your presentation all the input, but I'm not sure that Honorable Namdas will appreciate if I give him back the floor for the conclusions, if his questions will not be addressed. So I don't know if Amadi Ba or Professor Kritsiodis are available to comment on his two questions. Amadi, please.
Yeah, I have, if I understand the question is about how to create an Islamic court or to involve Islam expert to better know.
Amadi, I think the question from Honorable Namdas is, how do the ICC investigators gain access to areas mostly controlled by Boko Haram? And he's referring to parts of northeast Nigeria. Okay. So I think it's more, I think as a legislator, he's concerned also about your security and, okay, your people there and the people of the civilians there.
For the security and access, at this stage, His Excellency have to know that we are not investigating, we were not in the field. We receive communications, which are documents, virtual, video, everything. The collègue analyze and cross-check. Je ne sais pas le mot recouper en français. Cross-check if really the source is a real one we can trust, if the facts, the events have really occurred, and they cross-check following all our means we have with NGOs, people, victims, etc. At this stage, Your Excellency, there is anywhere the court have deployed on the crime scene. Now, when we open an investigation, now we begin with the states, with our own means, internal means, and the security force support to access the security. And from that period now, we can have an investigation strategy, a cooperation strategy, and when we get enough evidence and identify the responsible, we can have a prosecution strategy. On the cooperation strategy, I give an example. Security did not allow us to go in Bangui, in Central Africa, in all areas where crime was committed, despite the fact that we have selected the most gravest incident out of Bangui also. What we did is we focused on Bangui at the first time, between the two camps, Seleka and Tibalaka. At the same time, we tried to deploy on this period, on this zone when security allow, or we use other countries, as I said. Congo Brazza is the neighbor. Chad is a neighbor. What country did we also get? Cameroon. Cameroon was, we negotiate with this country an agreement, which are sometimes written, sometimes ad hoc, to be able to go to the camp of Central African citizens to get cross-check our evidence and to get testify. It's how Plan E, there is no problem of security. Plan B, there is a problem of security. Our investigation plan, prosecution plan, and cooperation plan have to take in consideration the fact of insecurity and access. Last question, Islamic court or Islam expert. Your Excellency, the ICC you have ratified have tried to bring a universal law and a universal framework, despite what you believe, and have also selected judges despite the religions, etc. It means that what we did in the court here, also far to have reinforced the prosecutor, is when we have Islamic group like that, You have seen that they attack, they use political organization to attack people they qualify Mekreya. What is Mekreya? Someone who don't believe. They attack them. They attack what? In a very atrocious manner, these people who don't believe. They destroy the symbol of religion, which is not religious, of education. When we recruit people, before we begin the investigation, we train our investigator, mix them with people who have knowledge of this region and the problematic, to be sure that culturally, religiously, we have a legal and deep understanding on why this policy is used to attack civilians. You know, but it's not the fact of having an Islamic court or having an Islamic expert who can help. It's better to get the competent person selected, but you add specific knowledge like we did in Mali. We invite experts here to train our colleagues, but we use this expert to explain why in North Mali people have destroyed this cultural heritage, because for them Islam did not allow. But this expert explained to colleagues that these symbols are not just walls and stones, and explain why it is in the cultural property of Mali, cultural property of the continent and the whole world. It's just what I wanted to bring. Thank you.
Thank you, Amadi. And Professor Kritsiodis, I think you might have seen the question that Honorable Namdas is addressing to you.
I have, and I've responded to that directly to Mr. Namdas. That was that the social media clip was actually regarding Cameroonian soldiers, and I was simply saying that it wasn't just Nigerian armed forces that are facing accusations. If I may, Mr. Chair, I just have one question for my fellow panelists. My area of interest and speciality is international humanitarian law. So I defer to the international criminal experts in the session. But we've been hearing quite frequently about a situation where a government or government armed forces are firing on civilians. Now, historically, under international law, this is not an armed conflict situation, because an armed conflict situation, as we know from the jurisprudence in the international criminal tribunals, requires two factions, and they have to be organized and so on and so forth. And this is a long-standing tradition under the provisions of the Geneva Conventions. But the question I have to ask is it possible that an armed conflict can come into being where one side is the civilian population? We had in the remarks of Ms. Balagaya the reference to the 28th of September massacre in Guinea. But I'm thinking also of very recent developments taking place in Myanmar, where civilians are having to organize themselves in very limited space and time against the government. One could argue that the situation in North Korea, where the government is starving its population, is another example of this. So I'm just wondering, given the fact that in international humanitarian law, in an occupation situation, which can only take place in an international armed conflict, we recognize there are situations called levée en masse, where the civilians are becoming combatants, or they have to defend their lives. So is it conceivable that international criminal law may develop this idea of what is an armed conflict, and that we will be thinking of it in terms of a civilian definition?
Thank you, Professor. It's an academic question, but one with a lot of practical implications. If I can say one thing here, is that what I see from the Guinea preliminary examinations, as well as to a certain extent to the current situation in Myanmar, not the one relating to the Rohingya, that is also under the jurisdiction of the ICC because of the deportation of the Rohingya minority into Bangladesh, a state party. In these two cases, I would say we are looking at crimes against humanity committed in peacetime. So we don't need an armed conflict to at least put in play the functioning of international criminal law. Of course, your question remains of how far we can go in the field of IHL, and you really clearly identify an asymmetry of the law, because when there is an occupation, you have certain standards, but when there is not, what do we do? So I think it's a very interesting questions that maybe somebody wants to further comment. Otherwise, we will need to bring it to the next meeting. Ms. Balagaye, please.
Thank you very much for that. Professor, if I understand the question, it's essentially asking if when a government targets civilians and civilians organize themselves, whether in any situation that can amount to an armed conflict. And of course, we're talking about a non-international armed conflict. Without commenting on any specific situation, as you know, based on the work that we do, it's important to remain neutral. What I would say is exactly what David said in terms of where that does not amount to an armed conflict, we're looking at crimes against humanity. In trying to determine whether it would amount to an armed conflict, we'd have to look at those groups to see how organized they are. Do they have a respectable command? For example, are they organized in such a way that they're able to carry out attacks in a sustained manner? Or are we looking at, for example, the intensity of the engagement, meaning it is beyond skirmishes, riots, we're looking at two sides actually fighting. So the intensity, the types of weapons that are used. So we're still within the realm of IHL. And from what we see in a lot of instances, that threshold has not been met for it to then be called, for it to then amount to an armed conflict. And so for that reason, like you mentioned, even with Guinea, we just focus on crimes against humanity. If at any point that situation changes, meaning you could start off with crimes against humanity, and then subsequently events escalate to such a point where you can then say an armed conflict has been established, then we would be looking at war crimes, and in that context, non-international armed conflict. I'm not sure if I've answered your question, but it's more about the organization of the groups, the extent of the organization. It's about the types of weapons they use, the intensity of the fighting.
Exactly.
But perhaps I'll let Amadi add on that. And
no, I have
no. Priya is our expert as well.
It's so clear. You are the expert. I'm working on cooperation, but I learn a lot from my colleagues, because in the national level, we are used to this small crime. Any crime is small, but it's not at this level of gravity. But here, we told us in French, le glissement, from a small group, you think it's not organized, you can, in deepening your investigation, your evidence can bring you to a very organized group, and all will begin from that. And I think the colleagues have given the right answer. I learn every day from my PD and ID colleagues. Thanks.
Thank you, Amadi, and thank you, Professor, for the very, very important question. Before I gave back the chairmanship to Honorable Namdas and the closing remarks to Honorable Benjamin Zondu, let me just thank you for the extra time you've taken to be with us. Let me thank those who support the PGICC campaign, namely the European Commission, the Netherlands, Switzerland, Liechtenstein, and the Oak Foundation. And then let me just say one thing, that here at PGA, as Frederica said, we are determined to prevent international crimes. That's the main rationale of why we are into this. So the sole fact that legislators like you can work on legislation to incorporate, to ratify, to join, to discuss such issues is the way forward, because through you, we think we have leaders that can educate your communities so that these crimes are never committed again against your own peoples and our own communities. And no region, Professor Dino, no region is out of this. We have seen what's happening in Northern Ireland. It's a reminder of the past, we are seeing, I come from a country that invented fascism and all the mass atrocities that that ideology brought to the world. So I think we are all together in a global fight. And with that note of global concern, Honorable Namdas, I give you back the floor. Thank you.
Thank you so much for this wonderful meeting and the participants. I thank everybody that has joined us. I want to say on record that we in Africa, out of the 123 members in the ICC, about 33 of them are from Africa. This is to tell you that Africa is also concerned and interested in having these ICC issues in place, because we have more challenges than ever you can imagine, because the challenges are increasing on a daily basis. However, my question, some of the things I want us to address is that ICC has already gotten 4 convictions, about 4 convictions, and about 20 of them are ongoing trials. And I just want to know, is 4 convictions out of all, is it enough? What is the challenge? We expect that there should be given the level of investigations and the kind of cases that have been identified. We should have gotten more than 4 convictions, actually. I know that there are challenges of funding, and then there are also challenges of the fact that some of the police, they don't have the police institution of their own. They rely on countries' police, because up to now there are 14 people that are yet to be arrested. So what can we do about that? That should be a way forward. But I want to say that we are handsomely educated, and we thank God, we thank the resource persons that have actually given us some of these lectures and the professor. But I think I have one of my member who is also here to deliver a closing remark to PGA. We are very grateful. Please, more attention should be paid to some of the cases in Africa and especially Nigeria too. Thank you so much.
Honorable Namdas, you give us back, you call us back to give the floor to Amadiba for maybe a couple of minutes. And then I think Honorable Benjamin Mzondu will have the final words. Am I right?
Yeah.
Perfect. Amadi, please.
Certainly I don't follow, but what Excellency have said is very clear. I think I talked a little bit about statistics sometimes did not indicate success. You know, sometimes I can have, yeah, this is 45 requests responded by states, but did I have the real evidence allowing judges to get conviction? This is the problem. And this is not only a single problem you can solve in this workshop. It's why after every time we lose a case, we're trying to do an objective lesson learned involving professor like our colleague Uto, involving expert to see where we fail. It is an objective process, and we will do it, and we did it also in Kenya issue, in etc. Second, Your Excellency, statistic in justice is not, I talk even in the national system, because I was heading the School of Judges in Africa, in Senegal, and I tell them, it's not the numbers, but the impact of your decision. We have 4 convictions, but you see prevention. You see what happened in Senegal some days ago. Police did not shoot. No, it's an investigation. I have not to. But if it was some years ago, it will be a lot of death and shooting because there is no court. And take even the manifest, the crowd, people go out. There is a liberty in Africa. People are being out and being loud. What they did not do along years ago. We have no statistic to demonstrate it because of the court, but we are sure that Minister of Interior and Minister of Justice and President are telling, please take care when you counter this manifest. Don't kill people because of ICC. Even in politics, following what we learned on Kenya case, people are doing careful to tell their people, go do politics, but don't kill. Because if you don't tell your people to refrain from violence, it's you who will be responsible because of the Kenya lesson learned from the principle adopted by judges they confirm a case law. It's why, yes, to be frank, when you take the numbers, we can tell ICC all this million. You have even this criticism in the web, or professors or people who are very aware of justice. But let's be a little bit careful. This court is not set for numbers of conviction. This court is set for you to investigate the case. And as I go back home, for the court, a little people, little in different organs to follow up on why you are doing it genuinely. In future, the success of Rome Statute is because every state is equipped to do what ICC is doing. And it's not what we believe really on that, and it's how you create the court too. Thank you.
Thank you, Amadi. As always, you enlighten us, and this brings me to the concluding statement. Honorable Benjamin Zondu, I know you waited a lot, but please close the meeting, please.
Thank you so much, Mr. David. My speaker, ably represented by the Honorable Nicholas Osai, very senior parliamentarian. My chairman, the PJ chairman, who is also my chairman, Honorable Namdas. Honorable colleagues from Nigeria and West Africa, our resource persons ranging from professors, legal luminaries, prosecutors at the Hague, and also our own parliamentarians who also were our resource persons. And our moderator, David, you've done a great job. My role here is very simple. It's been a pleasure for every one of us and all the participants. And this interaction has been educative, thought-provoking, it's inspiring, and pointing us to the way forward. The knowledge and experience gained here will inspire us to strive for actions against impunity and mass atrocities under the Rome Statute and the promotion of the rule of law in our society and in our various countries. Today, if you look at the issues of school adoption in Nigeria, it's throwing out a lot of children out of school, further swelling the already mammoth crowd of out-of-school children that we have. One area we also need to strengthen is looking at the consequences for these crimes. Are the directions of the consequences going in the right way, or we need to review them? We'll also look at how the issues at the Hague can be hastened up, and the issues of domestication. We need to, hello? Hello?
We can hear you. We can hear you. We heard everything.
All right, thank you. We need to look at issues of domesticating most of these treaties, protocols, and agreements, like what is happening in the Guinea-Bissau. We're very happy with the progressive work going on there. And I think we're also very happy with what is happening in the Gambia. We'll be looking closely with that report as presented by Honorable Njia. We are happy to know that the Gambia is doing a very progressive work on their human rights bills and all of that. The situation in Nigeria is very precarious, but government is doing her very best and will continue to do best to make sure that these issues of human rights are greatly taken into place. As parliamentarians, the engagement has really moved us forward, has encouraged us to do more. Recently, in the Parliament of Nigeria, the Speaker set up an ad hoc security committee comprising all the other security committees to make sure that the issues of insecurity are also tackled, the issues of legislation in terrorism, and other legislation that will aspire us to promote human rights and the protection of the rights of women and children. I think PGA is really excited with the development that is happening across the West African sub-region. Though for the challenges are there, they are obvious, but as parliamentarians, we'll continue to bring out these legislations and see to it that our oversight functions are properly carried out so that these legislations are also very implemented. Once again, on behalf of the chairman and every one of us at PGA, we are very grateful to all of our resource persons. I will not be going name by name so that I don't murder anyone's name, but we are really grateful for every one of you. Your knowledge that you have impacted will inspire us to do more and to look at more legislations that will bring about an end to impunity and that will promote the rule of law in our various countries. Thank you so much, and God bless you all.
Thank you very much. And apologies for the misspellings of the names. Bye-bye.
Thank you, bye. We appreciate.
Thank you so much.
That's
We will send the summary, action points, and all the follow-ups that we usually do.
Thank you.